Konnichiwa, motherfeckers. Welcome to this week's episode of Law and Ordinary People. I'm your host, Brie Heffernan, and I've got the best questions in the world sent in by some of the viewers this week. As you all hopefully know at this stage, you can send your questions in to me at brieteffernan@fecttv.com or get us on our Facebook page or on our Twitter. First, before we kick off into the questions, I just want to remind you that while we do our best to give you accurate information, every situation and every circumstance is different, so we can't guarantee that every answer we have is completely correct. And if you have a problem, you should speak to your own solicitor, because solicitors really are groovy. Okay, our first question today came from Neve. She says, "Hi Breed, I went through a very bad breakup recently and haven't been able to stay friends with my ex. A few months have passed, but now people are coming back to me telling me ridiculous things he said about me. He's telling lies about the things that happened during our relationship, etc. Is that slander? And if it is, what can I do about it? Please treat this as urgent as I'm going crazy." Well, Neve, I'm really sorry firstly to hear about your breakup. That's really, really crap. And it actually sounds like you've had a lucky escape, but that's neither here nor there. Firstly, people ask me about slander the whole time. Yeah, it is technically a law and it does exist and things, but it's probably not going to save you in this situation very much. You see, in 2009, the Defamation Act was written and that came in 2010, which means there is no such thing as libel and slander anymore. Slander used to be when someone said something about you that was untrue, and libel was when they wrote it. But nowadays we just have the tort of defamation. So just defaming a person. But defamation generally doesn't save people in circumstances like you. I mean, yes, it should, and technically the law is there, but well, this guy probably doesn't have the money to go through with it. Technically what he did is defaming you, because defamation covers whether you said the thing or you spoke it, as long as it's to a third party and not just you yourself. Like if he said it to you directly, he can't be defaming you. He would have had to say it to someone else, but it sounds like he did. So technically, because people have the right to a good name, which is from the Constitution and now in law, yeah, he's defaming you. But there are defences to defamation, such as truth. So if he was telling the truth, it's not defamation. But I mean, technically, he probably doesn't have the money to pay you anyway. You'd need proof. You need more than just allegations, and there'd have to be quite a wide publication of the things in questions. So while it's really annoying and it's horrible that he's doing these things, you probably won't have a good court case out of it unless he's published it in a newspaper or done something really big with it. It's horrible, but you just sort of have to deal with it. It's sad. The next question is to do with contracts. It comes in from Dave Kennedy. He says, "Hi Breed, last week you mentioned about unilateral contracts being by one side and catching people. I thought a contract had to be in writing, signed by both parties, and each side had to have a copy of the agreement in order for it to be binding. Can you just explain that to me, Dave?" Well, Dave, that's actually a really great question. I'm so delighted someone asked this, because people don't get this and people get confused the whole time on contracts. For a contract to be valid, there's a few things you need to have. Firstly, you need to have offer, then you need to have acceptance, and there needs to be consideration. So an offer is a very clear offer. Some people get confused between offer and a thing called an invitation to treat. Like if you're in a shop and you see a drink for €10, that's an invitation to treat. That's not actually the offer. The offer is when you bring it up to the counter and offer them money for it, because they're not bound to accept it just because their sign says €10. Otherwise, every kid that walks by could have it. So that's only an invitation to come in for an offer, sort of a thing. So that's your invitation to treat, an offer. Then there has to be acceptance, and that has to be clear and by both sides, not a counter offer. Just has to be acceptance of your offer, and then consideration. So consideration is money or money's worth. So either doing something or something that's worth money. Then there's another thing called intention to create legal relations. Like if it was something very blasé, there was probably no intention to create legal relations. Or if it was like a social thing or something, there would be no intention to create legal relations. So that does sometimes catch people. But you asked, like, does something have to be in writing and signed by both parties? No. I mean, you have a contract, like that case with the buying a bottle of drink in the shop. You have a contract because you've bought it, and that's why consumer law and contract law and things would catch you. even though you don't have a written contract. Never for contracts is there going to be a requirement, unless you make it yourself, that each side has to have a copy of it. But there are some occasions when you do need to have something evidenced in writing. That's like if it's a contract to do with land, so like buying or leasing land or something, or a contract that has something that's over a year in duration. These sort of things do need to be in writing, but not the average contract, so don't mind that at all. It's a really good question, and not enough people understand contracts, so I'm delighted you asked. So the next question we have, moving swiftly along, is from Michelle, who says, "Hi Breed," it's Breed by the way, "I applied for a job a few weeks ago, but didn't get it. I got a call to an interview, did a great interview, and thought it went really well. I found out a few weeks ago the person who actually got the job, it turns out her daddy knows all the right people and she's a complete stuck-up cow. I come from an area that's not very rich, but I'm sure I had better experience and better qualifications than this girl. Is it possible to claim that I was discriminated against by the employers? Yours, Michelle." Well, Michelle, under the basic laws of discrimination and equality, it's not looking good. There are grounds of discrimination, but they're specific grounds. You can't just say, "I was discriminated," and leave it at that. The grounds that someone can discriminate against you, where it is not okay, are gender, marital status, family status, age, disability, race, sexual orientation, religious beliefs, and being a member of the travelling community. So if you think they discriminated against you for any of those sort of reasons, then you might have a case, and then you should by all means head off to the Equality Tribunal with not having got this job. But it doesn't look like there has been discrimination on one of the 9 grounds for you. You just say that they liked her family more, or she knew the right people. Unfortunately, and it's so annoying and so frustrating, but unfortunately that's not grounds for a complaint and discrimination. It's crap, but that's how it is. Maybe you'd have a case with the travelling community thing, but it's pretty slim, I'd say. Tough luck. The next question comes in from Mary O'Dwyer, who says, "Hi Breed, I hear a lot of people saying that the reason the judge let the man who was accused of raping his daughter as frequently as having dinner go free is because of precedent. What is precedent, and why, when he was convicted, was he let go home? I know he's in prison now, but I just don't get it." Mary. Okay, Mary. I heard people talking about precedent too, more before Judge Carney came back and said that he was revoking bail. Precedent is sort of like a form of law that courts and judges have created themselves. Because we want the courts, you want to be able to predict how things are going to go. You don't want them to be making like crazy decisions and you can't predict it. They follow what they do in previous cases and what higher courts do, and it's called precedent. That's all it is. They've set their own precedent and they're following it. So it's like how you know whether your case will probably be successful or not. And it takes a higher court to sort of change precedent going forward. So that's all it is. It's just them following what they always do. It's the general rules. And that's why sometimes it's so hard to change law. In this case, the judge granted bail in the Central Criminal Court. But the thing is, no matter what court you're in, you have a right to appeal any decision based on either the severity of the sentence or on conviction. So conviction, say the judge said you were guilty, but you're still saying you're not. You always have one right of appeal. So in the Central Criminal Court, you'd go to the Court of Criminal Appeal. And in that instance, you need to get the judge in the Central Criminal Court, because it's already technical, to give you a cert saying that he'll let you appeal it because it's an appeal-worthy case. But if the judge doesn't give you that cert, you can still go to the Court of Criminal Appeal, but you're appealing the fact that the judge isn't letting you appeal. So that's just how it works. It's really technical and it's really messed up, but that's the system. So what Judge Carney actually did was he'd said it was an appeal-worthy case. And usually you've got 14 days to appeal a sentence. But the father didn't appeal. So nobody really understood why he let him walk when really he was sentenced, but he just let him go. So it does look like it was a bit strange. And I think Judge Carney himself has sort of said he was a bit confused and he wanted more clarification from other people, but he's revoked it now and your man's in prison now. However, you should know, like, bail, it's there because people are considered innocent until they're proven guilty. And I mean, even if you've seen someone pull a trigger or something, still innocent until proven guilty in court. It's just how our system works. It's like that ever since we started our justice system. So the appeal technically stays a judgment. It just postpones it. And that's why someone will have the right to leave the day they are convicted. When someone's looking for bail, there's things that judges take into account, like are they likely to flee the country? Are they likely to reoffend when they're on bail? Were they caught red-handed? Whether they might interfere with like evidence or witnesses or jurors or something. Whether they have a history of breaching bail bonds, what kind of character they have, their circumstances, the seriousness of the crime. There's loads of things. And I'd say in this instance, Judge Carney gave him bail because he's probably not likely to reoffend because he's old and sick and everything. And he's probably not likely to flee the country. So he's actually pretty good candidate for bail, apart from the fact that this is a serious charge. So I think Carney just weighed it up and he's just sort of, day one, went in favour of the father. However, he's now come back and he's now behind bars, so everything's actually pretty okay. But yeah, so that's your answers. As always, if anyone else has any other questions, any other legal questions, feel free to send them in to us, Brí Teffernan and Effect TV, or get us on Facebook or on Twitter. After that, stay safe and remember, we're all just ordinary people.